down the brain. And I've actually seen you both before, and seen you both on the political campaign for other, positions in the past. And I just wanted to ask you both, your experience as far as the political process, judges running, and do you think this is something that should continue, or would you like to see this political process change to an appointed position?
It's Ken Pollock, and that's an interesting question that the voters are going to have to contend with in this election. Both systems are very political systems. It all comes down to, I guess, from the voters, who do you want deciding who your judges are? Because in both cases, it's going to be done with political considerations, and there are other options out there other than what they're currently faced with. Personally, my problem with the proposed Nevada plan is who's selecting the judges through the panel. You have a panel that's comprised half selected by the state bar, and then half selected by the governor, and the way the terms are staggered, unless you have a governor that's been reelected, generally you have half of the governor's appointment by a different governor. So it has no accountability to the voters, because even the governor's appointments may not be the current governor. If we had a system where the voters elected the Commission on Judicial Selection, that may be a better system. But with what we currently have, my confidence is with the voters. Yes, we've had some instances of problems, but in each time where we've had problems, the system has worked, and the voters at the next election have had the opportunity and did remove the individuals, even with charges pending by the Judicial Discipline Selection, who also removed the judges. So we have a double check on problem judges.
Susan Scan. I think the central issue is here is how do we get the most competent judges on the bench? I've served on a selection panel, merit selection panel, and the three people that we passed forward, and this was in federal court, but the people that we passed forward were competent individuals. From there on, it's purely political, and there's just no question about that. Because I think it's important that the voters have a say. What we have coming up in terms of an appointment followed by having to run so that the voters still have a say, I think is an alternative that is more likely to ensure that there are competent people on the bench. Because when there's an election process, anybody who's got 10 years of admission to the bar can run, and then it's a position of getting out and how are you known in the public. People don't. Another thing that discourages me at times is that the voters don't come to judicial forums, don't get to know who the candidates are. And if there's going to be a vote on candidates, there really need to be a study and to know who they are. The other problem about running for election as a judge is that you have to raise money, and that is something that can create an appearance of impropriety. It doesn't necessarily mean that there will be an impropriety, because that's the way that we're funded, and we have limits on contributions in this state. But still, the office and the process don't match up very well. I think that you get both when you have an appointment system that goes through a merit screening panel, and then the voters do get their say. Because if you have a judge who isn't good, the voters turned out the last judge who wasn't good and did it more promptly than the system did. So I think that's an important safeguard that needs to be there. But the question to really ask is, how do we get the best judges? And I think having a screening panel look at the people based on my own experience and just the people that I've seen who've gotten through the panel, they at least have an amount of competency.
This is Nick Starling, Public Relations Officer for Veterans of Politics. Just want to thank you for coming out and answering these questions to the best of your ability, and also for being involved in your community. Do you have any follow-up comments? We have about 3 minutes, so that leaves about a minute and a half for each of you.
Okay, it's Ken Pollock. I want to thank you for the opportunity to visit with you. In terms of being a judge, I guess I need to answer the one question that wasn't asked today, but I'm asked all the time on the campaign trail. Why do I want to change from the family division to the civil division? And the short answer to that is a decision that the Nevada Supreme Court issued on December 24th, Landreth versus Malik, which fundamentally changes the jurisdiction and how we divide cases between the divisions. Because of that decision, cases that were being heard in the family division will now have to be heard in the civil division, so we need to transfer resources between the divisions. My experience among the family judges probably makes me the most suitable of the family judges to make the jump over to civil. So it's just a method of reallocating resources within the court.
Susan Scan, I've read that Landreth decision too, and what it talks about is that the jurisdiction is in the general civil courts to general district court if you have parties who are not married and you're dividing their assets. That is a partition action. The present civil judges have done that as long as there has been civil courts. So I don't see that there is any need for a transfer. What the legislature did was they created 7 new civil seats, and they should be 7 civil practitioners. There doesn't need to be any reallocation of resources to family court because these matters are things that have been traditionally dealt with by district court and can continue to be dealt with by district court.